Okay, so now let's talk about some other documents Lori Vallow has filed about what she wears and how she is treated in the courtroom. She's had on handcuffs and ankle shackles every time. And as she said last time, a shock vest, which was kind of news to me. I didn't know those things existed, to be honest with you. But she has now filed a motion in her own handwriting again about what she hopes will happen at court. And that she wants to wear normal clothes. Let's dive in for this one. Lori Vallow requests this court wear civilian clothing during court proceedings, jury selections, and all trial proceedings. The public and prospective jurors are viewing the defendant's proceedings on worldwide media, hopefully just East Idaho News. Nah, just kidding. But you can watch it on East Idaho News, by the way. The defendant's appearance is, if in jail uniform, will constitute a violation of the defendant's due process rights. And then she quotes the Sixth Amendment. The state or Madison County's failure to adhere willfully or inadvertently would deny and violate the defendant's due process rights. Therefore, the defendant requests that the court order to allow the defendant the fundamental right to wear civilian clothing in all court proceedings, jury selection, and both trials. Then she files another motion. I'm just going to scan through it here. The defendant requests the court allow the defendant to have no restraints, handcuffs, or shackles while in the courtroom during all court proceedings. This request is made pursuant to the 14th Amendment, 5th, 6th, and 8th Amendment. On December 6th, the defendant was granted self-representation. It has been extremely difficult for the defendant to manage files, take copious notes in all pretrial hearings with handcuffs. It would be impossible to represent oneself at trial under these conditions. Also, the defendant's appearance in restraints, handcuffs, or shackles violates her due process rights. It impedes her ability to perform writing tasks in her defense. If the defendant is going to properly be allowed to, quote, defend herself, she must not appear separate or different from the state representative. To be able to stand, walk, move about the courtroom as the other attorneys is imperative in a fair trial. If any imposed Madison County Sheriff's Office restraints cause this defendant to appear to the jury different from the state's representation, it would violate the defendant's due process rights and the right to a fair trial. This defendant's documented behavior for the last 5 years while in custody warrants no restraints necessary during trial at all. This defendant has been through a long trial without any misbehavior at all. This defendant has only displayed stellar behavior all of the time that she has been in custody and incarcerated over the last 5 years. Therefore, the defendant requests that all security restraints be waived for this particular defendant. The defendant also requests the use of a pen at her trial table to take notes. At the minimum, the defendant requests this court to order the state and the sheriff's office remove restraints, handcuffs, and shackles for all trial proceedings, both trials. Well, Lori is right in the fact she has behaved at all court proceedings, and she didn't cause any issues in Idaho. She wasn't, I don't believe she was handcuffed in Idaho. I'll have to go back and check. I can't believe I don't remember. There's been so many of these hearings. If you were there, let me know in the comments if you remember. So here's the thing. The judge on these, the judge already ruled on the clothing, and he said she could wear normal street clothes during the trial and jury selection, but all other hearings she can't. She has to wear her outfit, her from the jail. The sheriff actually responded to her request with this as far as the shackles and the clothing. The sheriff said the judge already ruled on the clothing, no use for, talking about it. But talking about having the handcuffs and the shackles removed, this was pretty interesting. The sheriff said, and let me pull this up over here. There we go. In the defendant's case, the sheriff's office has reviewed her request and recognizes that she needs to move about the courtroom. However, pursuant to policies and procedures and the sheriff's office duty to maintain control and custody of inmates and to ensure the safety and security of the courtroom, the defendant cannot go unrestrained. As such, the sheriff's office recommends the use of a RACC vest, and in addition to the detention officers in the courtroom during defendant's trial. And I think they mean an addition, like having more deputies in there. The RACC belt is designed to temporarily stun an attacking detainee, thus buying time for courtroom security officers to react. The belt sits comfortably on the defendant with straps adjustable to a particular defendant's body type. The belt is not visible to the jury. Further, the belt works on a one remote, one sensor system, ensuring that activation of other remotes will not trigger the vest accidentally. These two security devices permit the sheriff's office to restrain defendants in the courtroom. Without any restraints, we'd have to recommend an unarmed detention officer and an armed sheriff deputy in the courtroom. And then the sheriff said, after reviewing her motion, I have the following recommendations. Normally, inmates attending a trial wear a leg brace and a RACC belt around their waist, which allows detention officers to deliver an electric shock by remote control. These two devices are worn under the clothing of the inmate and are not visible to the jurors. Handcuffs, leg chains, and inmate uniforms are not worn while in the courtroom. She has been wearing handcuffs. And this is done specifically to prevent jury from knowing the defendant is currently an inmate. Okay, so it sounds like during trials, they don't wear the handcuffs. The jail staff maintain control and custody of the inmates during transports to the jails and all back and forth. Once an inmate leaves a secure jail facility, all inmates are restrained while outside the facility. In this case, they could remove the restraints while she's in the courtroom, and she could wear that RACC belt and vest, which isn't seen from the jury, and a hidden leg brace to restraint to limit mobility. And so they're saying maybe, she can see because she's her own attorney, she needs to move around. She might not need the leg brace, but there's no reason that she wouldn't need the RACC belt. So that's pretty interesting. I did not know about this RACC belt. I don't know if I've seen that in Idaho, but I'm going to check, and maybe we'll do a story on what is a RACC belt. And I don't know if it's like a taser, if you feel a little jolt or something, but obviously it's enough to kind of get the person to pay attention and behave and not run away, which you need these days in court proceedings because you've seen it all the time. We saw it in that video of the guy in Vegas who jumped over the desk. I think it was Las Vegas, and attacked the judge while she was on the bench. It was startling to say.